Good morning, everybody, and welcome to our presentation on the eviction process. This is a very special workshop. It's designed to help people understand the eviction process itself. We talk a little bit about the law, but mainly we talk about how in LA County, a tenant can defend an eviction, including where to find legal representation. It is very, very important for tenants to have representation in evictions. In 2002, in LA County, 73,000 families were evicted legally through the court process. Of those 73,000 families, less than 2% had help. And 99% of the tenants that went to court alone lost their cases. Approximately 49% of them couldn't even file an answer and lost automatically. And of those that filed an answer, less than 2% had representation and 99% lost. Those are horrible, horrible statistics. Things are much better in LA County partly because two agencies developed an increase in services by charging based on ability to pay. That includes my agency and another one. And then eventually in 2018, we formed something called the Right to Counsel Coalition that includes all 11 legal services providers that are nonprofits and 13 organizations that do tenants' rights organizing. And through that effort, and especially with the support of the city and county of Los Angeles, we are at a place where I would say we're meeting probably 90% of the legal needs of the people who find out about us. I think we are pretty much responding to about 90% of the inquiries with either counsel and advice or full scope representation. During the pandemic, we are doing all of these webinars. There are 2 or 3 webinars a day. And anybody who is not yet in eviction court needs to come to the webinars. And at the end of most of them, there are one-on-one consultations with an attorney. We are not opening cases before an eviction is filed in court because there's just too many. But for instance, if you're on this webinar, you get the information, you get to ask questions at the end, and I give you information for where you can get that one-on-one consultation. And if you just keep coming back and getting consulted, you should be fine and prepared to either avoid the eviction, or if an eviction is filed, you will know where to go for help. I encourage you to stay connected with us. Sometimes it's frustrating and people give up. If I could ask everyone to please mute. And people give up, and then they come back to us with a sheriff's notice to vacate, which is the last 5 days. And that notice to vacate could have been completely avoided had they continued coming to the webinars. Okay, so please stay connected. I'm going to speak briefly for those of you who are here because you know that something changed effective October 1st, which was yesterday. I'm going to speak very briefly about that now, but that is actually the subject of the 1 o'clock webinar. And if Kevin or Harriet can put that up on the chat, where you go at 1 o'clock to get the details of the changes in the law, that I would appreciate that. But very briefly, tenants in LA County are protected at various levels by various laws. For a while, we had a federal protection, which everybody called the CDC moratorium. It was not a moratorium. It did not prohibit evictions from being filed. If everybody could please mute. It was a protection against being evicted. And the Supreme Court found that protection to be unconstitutional, so we lost it a couple of weeks ago. But honestly, it didn't affect most people in LA County because most people in LA County are protected by a state law that changed October 1st and by local laws, either at the county level. So anybody in the county is protected by the county law, unless you have a stronger city law, in which case you're protected by your city law. Those protections were enough to protect most of our population, exception people who were already in eviction proceedings before the pandemic started. And those people were being protected by the federal CDC order. So when we lost that protection, probably about between 1,000 and 2,000 people, I would estimate, in LA County lost the protection that was keeping them in their homes. Eden had been working with about 258 of those people and had whittled that number down to about 20 or 30 that were affected by the loss of that law. Didn't affect most of you, or any of you probably. What you are protected by is the state series of laws, AB 388, SB 91, and AB 832. Each one was a change in the law. And what the current status, effective October 1st, for those of you that have not been able to pay rent, between March and the end of September, March of 2020, end of September 2021, if you missed any payments during that period, where you now stand is the following. If you sent a declaration to your landlord that you were not able to pay rent due to COVID, which we've been telling people to do all of these months, everybody please mute. If you sent a declaration to your landlord, and if you paid 25% of your rent from September to September, the landlord can never evict you for those months, ever, ever, ever. Can't evict you. You still owe the rent. So you should all be filing applications at housingiskey.com for the state to pay that rent. The application is cumbersome. Work through it. There are people on this call who have worked through it and often offer to help people. So work through it. There are also numbers that you're given numbers that you can call so that you can get help. Work through it. File the application. If you do and you are approved, your rent arrearage will be covered. The rent you owe will go away. And it also offers you eviction protection. For anyone that cannot pay rent starting October 1st, the landlord can serve you a 3-day notice to pay rent or quit, and they can file an eviction action, but they have to tell the court that they have applied for relocation assistance. And if they have not, then the court will not issue them a summons. The summons is the document that gives the court power to evict you. Without the summons, the case can't move forward. So the landlord has to at least apply for rental assistance before they can try to evict you. So there's still some protection at the state level. And the rental application, the application for rent relief, can cover 15 months, including prospectively through December. So please make sure that you file that application. Some of you might have concerns about being evicted for other reasons. Whether or not you can be evicted for other reasons depends on where you live. It depends on whether your unit's protected by a local rent stabilization law or by the state Tenant Protection Act, all of which put restrictions on evictions. In LA County, there is protection against no-fault evictions, no-cause evictions, and evictions for extra occupants and pets and the noise they make. And that protection is in place through January 30th of 2022. We just got that extended this week. There are also some stronger protections in some cities. City of LA, for instance, has a stronger law. Rich, can you close this door for me? City of Pasadena has a stronger law. There are about 40 cities in the county of Los Angeles that have stronger laws. Okay. I'm gonna, so if you live in the county of Los Angeles and you have a notice of any kind or are being harassed by your landlord, the webinars is the place to go. And Jaylin or Kevin or Harriet, can you put all the webinars up right now? Webinars, get information, ask your questions. That's the place to get help if you're not yet in court. If you are already in court proceedings, we will put on the screen where you can get legal help. The 11 legal services programs have divided up the courts in the county. So for instance, my agency represents people in the downtown court, Pasadena court, West Covina court, and now Compton court, but only for tenants that live in the city of Los Angeles whose cases are in Compton. So if you fall under those categories, to get help from us, you go to E for eviction, D for defense, N for network, dot, L for loss, and A for Angeles. edn.la. It is that simple. No dots, no comms, no orgs, no nothing. edn.la. On that website, there is something called an eviction prevention form. And so if you fill out that eviction prevention form, you can get help from us. If you don't have your case in one of those courts, or if you don't care what legal services program of the 11 is going to help you, you can go to stayhousedla.org, ask for legal assistance, and get assigned to any one of the other 10 legal services programs. If you have a problem, there isn't a response to your inquiry, or the or whatever problem, you can come back to one of the webinars that I do, and we'll put up I do the Saturday one at 9. I come on to council at 3 on Saturdays. And I also have office hours Monday, Wednesdays, and Fridays. So you can come to any of those and I will see what I can do. No promises, but I will advocate for you to get representation. Or if your lawyer is maybe, so often I say something here and then, okay, Williams, please mute. And I'll say something here, and then your lawyer will say something different. Don't contradict your lawyer. Just come back and talk to me, and then I will talk to your lawyer to see if maybe they're missing something or maybe I'm missing something, right? We are working as a coalition, as a team effort. And so we should be sort of bouncing things off of each other, especially when cases are difficult, and I'm happy to facilitate that. Keep in mind, however, that I am inundated, okay? Inundated. Most of you will all eventually get my cell phone number out of me, and then you'll start texting me. The cell phone is for emergencies only. So I get very annoyed when people suddenly, instead of coming to office hours, they're picking my brain or texting me when they're having brain farts in the middle of the night. Don't do that. It's extremely annoying that my cell phone has become virtually useless for an emergency, because it's hard to distinguish someone who's having a crisis, a real legitimate crisis, the landlord's about to lock you out right now, versus someone who just is having a hard time understanding what they heard at the webinar, wake up in the middle of the night, can't sleep, they have a question, and they text me in the middle of the night. Not all right. Okay, this cell phone is on all the time for emergency lockouts, so you need to come back to office hours to get more help. Okay. The last thing, somebody commented to me last week I had told them a million times that their notice was defective. Your notice is defective. Your notice is not valid. Your notice is defective. Your landlord can't evict you on that notice. But I guess in their mind, they didn't really understand what that meant, right? Because I didn't go on to say the following. If a notice is defective and the landlord files a lawsuit for eviction based on that notice, you're going to defend that lawsuit, and we are likely going to win that lawsuit. And in the course of that litigation, either the landlord will give up and let you stay, or will negotiate a deal that you can live with for moving out, usually with saved rent and some money in your pocket. So when a notice is defective, we don't run to the landlord to say, hey, your notice is defective, because they'll just fix the defect and serve you one that's not defective, and you'll get evicted quicker. But if there is an issue with the notice, it's a defense, and we use that in the litigation to help you reach your goals. That's one thing that I think people need to know. The other thing is there's a lot of fear of illegal lockouts or harassment. Frankly, some people are afraid of harassment when they just need to let it slide off, okay? If your landlord is texting you constantly, emailing you constantly, and calling you constantly, I don't know why you're answering. Block the texts, block the calls, send an email and a text that says, I am not going to communicate with you. You are harassing me. I am blocking you. And then ignore them. You also need to all join your tenants union and the Alliance of Californians for Community Empowerment. Can I get those contacts up on the chat as well? Tenants union and ACE, or tenants together, because those organizations are fighting for changes in the law, but they also protect their members. If your landlord comes and locks you out and you call our emergency hotline, I will reach out to those groups, but they are overextended. And most of them are now only responding to defend their own members from illegal lockouts and illegal utility terminations. So please join, because if you're a member, they're going to protect you. They're going to send a whole bunch of people to confront your landlord. They're going to send a bunch of people to talk to the police when the police start taking your landlord's side. So if you're being harassed, step one, block the text, block the emails, block the phone calls, don't answer, and join one of these organizations, and they will give you a sign to put on your door. So when your landlord comes to knock on the door, it also says, don't knock on the door, don't text, don't email, don't call. Give me a formal notice and I'll take it to my tenants' rights organization and our solidarity attorney. It is effective and it works 90% of the time. There's about 10% of the landlords that will still continue to harass, and then we develop a special plan in those cases. But those plans get developed through the tenant unions and ACE or tenants together. So you have to get involved, become a member if you have a harassing landlord. Okay, I think that should have covered the main concerns that I keep getting on both the cell phone, the lockout hotline, and through intake. We have intake through a lot of different means. So take heed on what I just said. I am now going to talk about the eviction process itself. Okay. And here it is. This is a simplified diagram of the eviction process. Evictions start with a notice. The notice can be any amount of days. The most common are the three. Currently, the 15-day notice to pay rent or quit that we're not going to see anymore because that law expired on the 30th. 30-day notice, 60, 120, but it could be any other number of days. To do something or quit, which means get out. So it could be to pay rent or quit, pay the rent you owe or get out. It could be to cure or quit, meaning stop violating your lease or get out. Or it could be just a quit because you've done something so egregious that it can't be fixed. We just want you out. Or it could be a 30 or a 60-day notice to quit for no reason at all, because you don't have any rent stabilization protection. You don't live in a city with rent stabilization. Your unit's not protected by the state law either. And if you come to the, I'm actually not sure if we're doing that at the 1 o'clock webinar right now, but I have to figure out what's getting covered at each webinar. But bottom line is you need to go to a webinar that covers the rent control part of all of this. And so you if you don't have protection from a rent stabilization ordinance, then you can get a 30 or a 60-day notice, but not during the pandemic in LA County, because you're all protected by the law in LA County that just got extended to the end of January. So those notices are invalid. If the landlord, if you don't do what that notice says within the number of days, legally, the only thing the landlord can do is file a summons and complaint for eviction. Now, illegal lockouts are up by 75%. That is a real concern. And again, if you think your landlord is the type of landlord that instead of going to court is just going to come and throw your stuff out and lock you out, and you're going to come home from work and you're going to be locked out, the best solution for that is to join the Alliance of Californians for Community Empowerment or Tenants Together and your tenants union, and let them know that you are worried about that so they can develop a rapid response plan to come out there. If you come home and you're locked out and you've proven to them that you're a tenant, they will break you back in. And the landlord will call the police and they will intervene with the police. And when we at the beginning of the pandemic, there were tons of volunteers willing to do this, and we were having like a 99% success rate at keeping people in. Now, when I issue a rapid response, I'm not getting any response from anyone because people are tired. But if you're a member of these organizations, then they do rally because they rally for their members. So please join. If the landlord goes the legal route and serves a summons and complaint, here's a good thing that is still in place from the last version of the state law, AB 832. The landlord will not be issued the summons. They can file the complaint. They will not be issued the summons unless they declare under penalty of perjury that they have applied for rental assistance and or that you're not cooperating with the rental assistance. If they don't get a summons, then they cannot move the case forward. They might serve you just the complaint, but it doesn't have the summons. So we don't answer it. You come and you get help and we verify that they haven't been issued a summons, and then you don't answer it. If you answer it, then you bring yourself under the jurisdiction of the court. So it destroys what we fought for, which is no issuance of a summons unless they declare under penalty of perjury that they're cooperating, they have filed cooperating with the rental assistance program. Once you get the summons and complaint, you have 5 working days to answer it. That is not calling the court, it's not calling the other side. It's a specific piece of paper that you should have filled out at an agency that knows how to fill these things out. And then a trial date is set. A trial date is set. The trial date is sort of a misnomer. The courts are very, very backed up. So what happens at the original trial date is basically figuring out, trying to settle, and if you can't settle, figuring out when the case is actually going to go to trial. Rescheduling. And cases get rescheduled multiple times before they actually get sent out to trial. Partly because it's a volume practice for both sides. So both lawyers have too many cases. So often one or the other is not ready or available to go to trial on the date the court has said. And often, even if both lawyers are ready to go, there isn't a judge available to hear the case. And so it might get continued again. Eventually, if it goes to trial, there will be a judgment. If the tenant wins, what they win is the right to stay in the unit. People often want justice. My landlord's been harassing me. They turned off the utilities about 20 times. They keep, keeping me away. I had a guy whose landlord would come. There was an empty unit next door. he'd put a boombox on at like 11 o'clock every night and blast it all night long and then come and take it out in the morning. And the police were not doing anything about it because there was, if everybody could please mute, because there was nobody there to answer the door. Um, so the landlord's been doing all these horrible things to you, but you cannot get redress for that in eviction court. You have to sue the landlord for harassment. You cannot get redress in eviction court. If you lose, then you have to move out. And generally, it's 14 to 21 days from judgment to a lockout by the sheriff. The sheriff will put a 5 day, this 5 days should be down here, a 5 day notice to vacate on the door, and usually comes day 6, 7, 8, 9, 10. You can also get on this, the fast route, if you don't file an answer. If you don't file an answer, notice to vacate, the sheriff will come. Throughout this process, there's things that happen: motions, discovery, negotiation. And so this diagram, which is exactly the same thing except a little bit more intense, um, this diagram shows that the same notice starts with a notice, summons and complaint served. When the summons and complaint are served, you'll get a courtesy copy from the court. It might come, I'm sorry, when it's filed, the court will send out a courtesy notice. It might come before you get the summons and complaint or after you get the summons and complaint. It alerts you that an eviction has been filed. They still have to hand you the packet, which is like 15, 30. I just got a 64-page packet, summons and complaint, lots of exhibits and stuff attached. Once you get that packet is when you have the 5 working days, but don't ignore the courtesy notice. The landlord may be lying and saying they gave you the packet, and then you're going to lose automatically for not answering, and we're going to have to prove to the judge that you never got it, and that's not usually a successful battle. So as soon as you're aware, if you don't get the summons and complaint handed to you, go and get the copy from the court. Based on this, you get the courtesy copy, wait 2 or 3 days to see if they give you the summons and complaint. If they don't, go to the court and pick up the summons and complaint. 5 working days, you file an answer. Okay. There are motions you can file: motion to quash, motion to strike, demur. We don't do those motions because all it does is give the landlord an opportunity to fix an error, and it gives you another maybe 10 days. We don't think it's worth it to do it. Plus, it alerts the landlord to an error that they then fix. So we don't do demurs, motions to strike, or motions to quash service of the summons. We just go straight into filing an answer. We then propound what we call discovery. Discovery is asking them to give us all the evidence they have against you. But they will then propound discovery. So you have to be available to answer those questions when discovery is propounded on us. When this process is over, and sometimes inappropriately in the middle of it, the other side will file a request for a trial. Then we will file, then there will be a notice of a hearing. It's supposed to, this trial, happen within 20 days. We have cases that are backlogged more than 8 months. We have cases from 2019 right now. If you lose the sheriff's 5-day notice, there might be some motions we can do, but generally not. And then the sheriff will evict. If you win, you will get to stay. Again, a very small box. You get the right to stay. You don't get a redress for all the bad things the landlord has done to you. If you do nothing, you go on the fast track towards the sheriff's notice. There are motions that we can do, like forgive me for, it's called mistake, inadvertence, and mistake, inadvertence, or excusable neglect. I didn't answer for these reasons. Frankly, the judges are very intolerant of people who don't answer, especially if you sit on it for a really long time because you thought there was a moratorium. That argument has not won us a single reprieve for a tenant. And so it is important that you be attentive to your email, attentive to your door, not avoid service. Someone knocks on your door and they want to give you legal papers, take them and then come to either a webinar or Stay Housed LA and let's get it answered. Okay. So throughout the process, again, there is negotiation. There's even negotiation after losing. We will often file an appeal. We don't take cases to trial unless we can win them. Sometimes we'll take a very marginal case to trial, right? Because the unit is very below market, the tenant has no place else to go, there's a chance that we could win, in which case we will do post-trial motions and negotiate. And if the post-trial motions are not successful, we'll appeal and negotiate. When you first come to us, we ask you to choose a path. The path to the left is the I am fighting for my unit path. It's the path that recognizes that we're in the middle of a housing crisis, because if you are kicked out of your home, the landlord can raise the rent to whatever the market will bear, whatever the next tenant's willing to pay. And that is what's fueling this huge, the evictions. It's the landlords evict people, harass people, push people out because they want to raise the rent to market. So if we want to put a stop to that, that means we want to defend every single case so that we can preserve the affordability of communities. Since May of 2016, rents have been skyrocketing. I don't know what causes that kind of housing crisis. I know it happened in the 70s and tenants mobilized, and that's why we have rent control in cities like Los Angeles, West Hollywood, Beverly Hills, and Santa Monica. And then in May of 2016, suddenly rents started going up huge amounts. I did a little sort of informal study when like all of a sudden everybody wanted to stay in their units and I couldn't figure out why. Prior to the fall of 2016, most of our cases settled with a move out because a tenant that's having problems with their landlord, if we saved them a couple of months rent, got them a little extra money, they could get another unit, comparable price, as long as were not a long-term rent controlled tenant. So about 2% of our caseload, 1% of our caseload went to trial. And it was always the long-term below market rate tenants. And then the rest, we settled them out. In the fall of 2016, I realized that we were taking 87% of our cases to trial. And that's a complete flip. And so I did inquiring of our clients and determined that the average rent for a single and Pico union had gone from $800 to $1,100 between May and the fall of September of 2016. And by February of 2017, $1,300. That's when we realized that we're into this huge housing crisis. This huge housing crisis led to more rent control laws in more cities and to the State Tenant Protection Act because people mobilized for those protections. So we are about keeping people in their units because none of those laws have vacancy control. Vacancy control means tenant moves out, next tenant pays exactly the same rent as the old one, steps right into the shoes of the old one. So the landlord has no incentive to harass so that they'll move out voluntarily, in quotes, has no incentive to kick them out illegally, has no incentive to file an eviction action because they're not going to get any more money by doing that. We need vacancy control, and we've fought hard to get it twice. Proposition 10 in 2018, Proposition 21 last year, and we lost both times because of vacancy control, vacancy decontrol, the ability to raise the rent to market is the holy grail for landlords. It's what they care the most about. So they will put in inordinate amounts of money to stop us from imposing vacancy control so that they can keep making money and keep making money. Okay. But that's the pay and stay road. The pay and stay road is what preserves housing, preserves affordability. But a lot of people want to move out. They want to move out because they have other opportunities in other areas, because they're tired of the harassment, because they're risk adverse, conflict adverse. And that's okay. That's your choice. You get to move out. Once you've made your choice, we help you figure out whether it's the right choice for you. And we use 16 factors to figure that out. So if you're a disabled mother with 6 children with an $800 rent controlled unit and you're being harassed horribly by your landlord, you need to buck up, suit up, join the movement, defend yourself, learn to be powerful, learn to stand up to your landlord by yourself. And when it gets heated, call in your tenant union or ACE. Because there is nowhere that you can go that paying that rent, not even to the middle of the desert in some tiny desert community, right? So you are going to fight for your unit. If you're a single individual, you're relatively well off, you're paying an expensive rent, and you have a really weak case, then you probably should be on this move out road. Let's get you out with minimum impact as possible. And everyone else in between, you got to figure it out, right? You have to figure out what's best for you. Sometimes people start on this stay road and then a good enough offer gets put on the table that we decide to get in a car and go all the way across here and put them on this road. And that's okay as long as it's for the right reasons. If it's because of fear, especially irrational fear, if you have a strong case and you want to do this, we really talk a lot about it before we the decision's always yours, but we talk a lot about it before we make this shift over here. Okay. Um, and if you thought you wanted to move and then you realize, "Oh, there is no place for me to go," and you want to go on this road, well, we can also talk about it. It's easier for me to help you make this decision to stay than this decision to go. Because again, we're trying to preserve housing, but ultimately that decision is yours. So let's talk about the 16 factors.
Elena,
Yeah.
before we continue, would you mind just clearing that little backup notice up there, just in case it um, intrudes into any of the slides? Perfect. Thanks.
Thanks. So the first is the value of the unit. What is your rent? For how much space and where is it, right? So is it below market? How much more is the landlord going to be able to get for this unit? And then is that unit protected? Is it protected by a rent stabilization law, a local law, or the State Tenant Protection Act? Or does it have a federal subsidy like Section 8 on it? Or do you live in public housing or in subsidized housing? Or do you have an unexpired lease? Most tenants are on month to month. Many are on a 1 year lease, and it is rare to have more than a 1 year lease, but occasionally we do get people with multiple year leases. And if you have a multiple year lease, then we can, and it's for a low rent, then we should try to protect that tenancy. The next thing we look at is, can we win? Number one, does the law protect this tenant? Number two, do we have the evidence that the tenant is protected by the law? And do we have good witnesses? And how likable is the client? And it shouldn't be about how likable is the client, but it's a very, very big factor. And I get into a lot of conflicts with my clients because they think I'm picking on them when I try to get them to speak in a level tone. I don't know if most of you, I don't know if any of you noticed, but when I first came on the webinar and before we started recording, my voice was a little bit more shrill because this is really my more normal talking voice. I'm a little bit of an excitable person. I run on a lot of energy. And so this is my more normal voice. I also have my pissed off voice. Like if you do something really stupid, you're going to hear this voice from me. If you don't follow my instructions, you're going to hear this voice from me, which is more of a scoldy voice. Neither of those voices are very pleasant. It is hard for people to hear you when you are angry and telling your story and you're telling it in this really angry tone. And nobody likes a whiner. And I don't do the whining voice very well. And then, yeah, 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 and then they did this, and then they did that. It is unpleasant, people. It's unpleasant for the advocates that are trying to help you. I spend my entire day listening to people who are either whining or angry, and it grates on your nerves. So it's hard for us to hear the story. But when you're telling it to a judge or a jury, forget it. They're not going to like you. You have to have this more pleasant, I call it my Disneyland princess voice. It's a more pleasant, soft, lower timbre tone, and you all have to work on it if there's any chance you're going to be telling your story on the stand, on the witness stand. Being on the witness stand is a lot of pressure. It's nerve-wracking. And so if you haven't learned to tell your story with a calm and pleasant tone, you're not going to be able to do it on the witness stand. I've had one client prove me wrong. I've been practicing since 1985. You figure out the math. And I had one client who was really obnoxious during interviews and refused not to be obnoxious. But the dude was an actor. When he got on the stand, he acted like the perfect witness. Okay. So unless you're an actor, um, uh, please take heed and learn to practice being pleasant. This also goes to how you dress. We give people instructions on how to dress for court, and then they show up in jeans, t-shirts, sweats, um, tank tops. Don't do that. It shows a level of disrespect for the court and the jury. And then we have to talk about other stuff like people with tattoos. I'm married to someone with a lot of tattoos, but um, it there's a lot of prejudice against people with tattoos. And so if you have tattoos, probably we should cover them. Other people say, I am who I am, and I'm not going to cover them. Well, we'll respect that, but know that it will impact your case. Um, uh, Same thing with like large piercings, looking very counterculture. For the most part, our jury is going to be middle America. And so if you look counterculture-ish, there will be there could be a negative response towards you, and issues of credibility might get decided against you. I had a young man who said he didn't care. He had these piercings. He was very alternative and he wanted to be alternative. And so, okay, well, if that's the case, as long as you know the consequences. Um, Being gay is very last year. Most people have gotten over the gay thing, right? Thanks to people like Ellen DeGeneres and shows like Will and Grace and lots of media stuff. Most people don't care if you're gay, but being transgender is still new and elicits negative response. I had a trans man for a client on a very difficult case where one key point was credibility and his credibility. His name was something like Sissy or Carrie or like, something very, very feminine. And so all the pleadings said this, the former female name, but he was now going by something like Max and wanted to be called Max during the trial. So I had that difficult conversation with him about how the jury was probably going to be uncomfortable with this, but he would not be put back into the, um, you know, uh, binary closet and wanted to use his chosen name and be presented as he and he gender pronouns. So I asked, one of my first questions to the jury was, I swear it was like the wave at a at a stadium, everybody's body position shifted. It was very noticeable, very visible, and then they all said that they would have no issue with the fact that my client was a trans man. But their body language told me something very different, because people don't just shift around in their chairs at the at being presented with a concept, unless they're uncomfortable, right? And I know they were uncomfortable because everyone's uncomfortable. I will reveal to you that I am married to someone who is a cis female who thought about transitioning. Their preferred gender pronoun is they. And I still can't get used to the whole idea, right? So if I can't get used to the idea, if I still have issues and concerns, then everyone has issues and concerns, no matter how cool or progressive you are. And if you're super cool and progressive, you will overcompensate on the other direction, but it's still going to be a factor. All right. So, so there's, and then the last thing that I'll talk about is race. We live in a racist society. And so if you are a person of color, there is it is going to have an impact on the case. There are tons of studies that show that the darker someone is, the less credible they are found. They are associated with negativity. And so, therefore, we need to deal with that. We need to be aware of that. And putting a whole, like if your client is Black, putting a whole bunch of Black people on the jury does not, first of all, it's illegal to make jury selection decisions based on race, but it also is it doesn't work because there is internal racism, and the same thing goes for Latinos. My worst jurors have been Latinos judging my Latino client. The, you know, Latinos, especially those that immigrated and became citizens, are pulled myself up from the bootstraps. I crossed the border and I worked hard and I became a citizen and I learned English. So there's a lot of prejudice against my client who didn't learn English or who is low income or hasn't quite pulled themselves up from the bootstraps. I once lost a case about breach of warranty of habitability, no hot water, and a pigeon and rodent infestation that was very severe because there was one guy who grew up on a ranch and took cold showers his whole life, and he was none the worse for it, and grew up against around animal feces. So what's the big deal? And he convinced the entire jury of that. So these things are very unpredictable, and there's a lot of stuff going on in this can we win factor. Then there is other leverage. um is there time to propound discovery? That gives us both leverage and also information that we need. Is there time to demand a jury? We get a fairer result with juries. I started demanding juries in every case when I lost a case in front of a judge, and I know I lost it because my client was male, Latino, and looked like a gangbanger. He has a shaved head, and I met him in court for the first time. The bailiff thought he was going to have a heart attack, so she asked me to talk to him because he was hyperventilating and really nervous. So I just decided to step in and do the trial. It was a very simple case, and he had all his evidence, but he was wearing a white muscle shirt, not appropriate attire for court, and I know the judge thought he was a gangbanger. He actually was a very soft, lovely, mentally ill gay man, it turned out, but he had this tough exterior, and his case was absolutely winnable. His bank made a mistake and bounced his rent and sent him a cashier's check payable to the owner. And that night, the owner came knocking on the door with a 3-day notice to pay rent or quit. And he tried to give the cashier's check and explain that it was a bank error, and the landlord refused it. That's an absolute defense right there if you are believed. And why wouldn't he have done that, right? He had it already. So the next day he sent it overnight certified mail, and the landlord acknowledged that he got it and claimed that the envelope was empty. Why would he send an empty envelope? The judge believed the landlord over the tenant on those facts, and I vowed never to do a bench trial again. We started demanding jury trials in every single case. Now, sometimes if we get a right judge, we'll waive the jury, but we don't waive juries until we know who our judge is. And so and that's why we demand juries in every case. But I can't deny that the jury makes it more expensive for the landlord. They have to pay their lawyer more money, and it makes it more time consuming because a bench trial will happen on that first day. There's a judge that boasts that she can do a bench trial in an eviction in 10 minutes. And yeah, she's about as fair as that. There's no way a tenant can get justice in 10 minutes. Um, but um, but it happens faster, even if it's just 2 or 3 hours in front of a judge. When you have a jury, you have to have a meeting for at least a day with the judge to figure out what the jury instructions are going to be. There's a lot of work that goes into preparing those jury instructions, how you're going to explain the law to the jury. You have at least a day of jury selection, and a lot more. The trial just goes slower because sometimes the jurors have questions, and so everything takes longer. And because everything takes longer, it's more expensive for the landlord. And so a jury demand can also be leverage for getting a settlement. Another leverage point is there a provision in your lease that says that the loser has to pay the winner's attorney's fees? That's a double-edged sword with the side with our side of the blade sharper, because it's easier for us to collect against the landlord than for the landlord to collect against a tenant. But and so often we will get a settlement on a iffy case because they don't want to take the chance that we'll win and will be issued attorney's fees. Another factor is the client's finances. If you are an upwardly mobile or affluent person with a regular paycheck, they will be able to collect that debt from you. So we have to take that into account in deciding whether or not to take an iffy case to trial. If you are a low income person, especially if your benefits are just government benefits, or if you don't have a paycheck, like you're a day laborer or you get paid under the tenant under the table, there's no way they're ever going to collect from you. And if you have an uncommon a common last name or a common name, and you don't have a social security number, again, how are they going to collect against you or ruin your credit? So we take this in deciding, okay, maybe we can win, maybe we can't. We have a very below market rate tenancy and the tenant has no place to go. The case is kind of iffy, but why not take the chance, because they're never going to collect or be able to ruin this person's credit for these, because a they don't have a social security number or a job. They're paid under the table. Okay. Um, but then comes the next factor. What are we risking? What's the offer on the table? And an example would be, you have a very below market rate unit, long tenancy, protected by a strong rent control law, but we can't win. The tenant screwed up. We really can't win. We've used all of our leverage possible to keep them in for about a year and a half. They are low income, not a common name, but no social security, and they make their living by recycling bottles and selling tamales on the street. And so they're not going to get, so like there's no way that their record will be affected by this, or that they will ever be able to collect. But then they put $75,000 on the table for them to move. So now we're risking something on a case that we can't win, but we might be able to get them a hardship motion granted, a motion for relief from forfeiture, so that they can remain as tenants based on their low rent, advanced age, extreme poverty, disability, etc. But is that worth it, right? Those motions are very rarely granted, and now we're risking $75,000. Okay. And then we would look at who the players are. Who's our opponent? Is our opposing counsel someone who prepares for trial, is ready to go to trial every single time, is a strong litigator, or are they one of these guys that will eventually fold and give us whatever we want in a settlement? We need to know who the landlord is. Is it one of the landlords on the list of the out of the principle of the thing, I'm not going to forgive any rent? Or are they one of the landlords that uh, we can get 3 months in a waiver of rent and a little bit of money, and we know that already, but we're not going to get more than that? Are they a deep pocket that we can get more money out of? Or are they a low income landlord that we're not going to get a lot of money out of? So you need to know who your landlord is. You need to know who your judge is. So we know who, like, what we have a list of the judges and how they ruled in past cases, what they're good on, what they're bad on, if they're fair to tenants, not fair to tenants, neutral with tenants. But where your judge is also dictates what your jury pool is going to be like. So if your case is downtown, the 4 judges in the downtown court, they're all acceptable to us. They're in the middle. We don't win every time, but we win when we should. Wobblers, well, a wobbler's a wobbler. Like, I recently lost a motion for summary adjudication in a case. But and I think the judge is wrong, but the judge's position is reasonable given all the facts in the case. So it's not that she was dead bang against the tenants, she just sees it the way the landlord sees it. Versus there are judges that you absolutely cannot win in front of if you're a tenant. So those we can ding one judge, we can say no to one judge. Sometimes we've dinged a judge and then gotten a worse one, but then that we change our settlement position at that point, right? Um, and so if your case is downtown, it'll be assigned to one of 4 judges and probably stay with one of those 4 judges throughout the life of the case. If your case is in one of the outlying courts, for various reasons, your case will not stay with that judge. It will be assigned to another judge for trial. And when we get that assignment, we reassess all of this based on the assignment. And the assignment also will determine the jury pool. So for instance, there's a very fair judge in Pomona Court that does UDs. He's also a great settlement judge. And he's a great settlement judge because most judges and mediators in settlement will assume the tenant is moving. It's just about how much time, how much waived rent, how much money. But that shouldn't be the assumption. I have had judges say, when Ms. Popp, what is your client's settlement offer? My client would like to pay all the rent and stay as a tenant. Ms. Popp, we want a real offer. Well, that is a real offer, dude. That is an absolutely real offer. And I then go into my speech about housing is a basic need and should be a guaranteed legal right, and we live in a country where we allow people to live on the streets, and that's disgusting. And I go into my whole political speech about it, and a pay and stay offer is an offer. But there's a lot of bias against that. Now, this Pomona judge, he agrees that he's very fair, including if we have a good case, taking a position that rather than waste time in a trial, that the other side should just dismiss the case. And so, but if the case goes to trial, Pomona jurors tend to be more conservative because it's a higher percentage of homeowners. And so, so we keep that into account. And then we look at the client. Is my client someone who went to all the webinars and got empowered and is educated about the law because they really understand what's going on? And I will cite Jalen Bailey, who is here, who is my perfect example of someone who came into this as a complete mess, and now is an empowered, educated advocate for tenants' rights, helping other people. Okay. And I always tell my clients that negotiation is a combination of playing poker, chicken, the game with the two cars going towards each other, and let's make a deal. And I'm very good at all three games. And I'm very good at negotiating and at really knowing, the song, you got to know when to hold them, know when to fold them, know when to walk away, and know when to run. I often use the analogy of Keanu Reeves and Patrick Swayze jumping out of an airplane in Point Break. I want you to Google it and watch it. It's the greatest negotiation of all time. They're flying through the air, plummeting towards the ground, and one of them either has to drop, one of them has to pull the chute, and they're both refusing to do it. And eventually, Keanu Reeves drops the gun that he's holding, pulls the chute, and saves them both. And Patrick Swayze goes away. In that negotiation, are you Patrick? Are we both going to die? Or are you Keanu? You're going to know exactly when the last minute is to give up on a case you can't win. So in doing negotiation, we have to consider all these factors and know if we can win, let's move forward. If we can't win, then when do we pull the chute? When do we give up? I have to say that Jaylin had a offer, and that's what she wanted, and she stuck to her guns. Now, we also had a winnable case. So the worst that was going to happen is we were going to win. She wanted to move out for X amount of compensation. They were not giving it to us, but she stuck to her guns and eventually got exactly what she wanted, even though I had said maybe two offers before. I don't think they're going to go anymore, Jalen. I really don't think they're going to go anymore. And I was wrong, right? So both I and the client have to work together. Ultimately, the decision is yours. If you're risk adverse and conflict adverse, then it's going to be kind of like the equivalent of I'm playing poker, I'm at the table, but you're standing behind me telling the other guy what my cards are because you've started moving out of your apartment so they know you got one foot out the door. That's a really good example. We never do that well when people start packing and moving before we have a deal because then they know you're already ready to go out. So you are an important factor. And then the lawyer that you have is an important factor. Now, a lot of people, I have over the course of the years gotten to be sort of a mean old bitch. I'm cranky as all hell. I get really like, I work all day and then I counsel people all evening on Mondays, Tuesdays, Wednesdays, and Fridays, and Saturday afternoons. There's a point where I'm like, I cannot hear another sad story or answer the same damn question again, and you'll hear it in my voice. This is the irritated voice, not very pleasant either, right? You'll hear it in my voice, but I care, and I'm still here, and I continue working with people. And if you don't like it, you can try to find another lawyer that's gonna have this conversation with you. And I do try to control it, although sometimes I'm like, okay. But I'm a really good trial attorney, right? And I train good trial attorneys. There are three of us in my office right now that are excellent trial attorneys. I have a lawyer in my office that's won 5 out of 5 cases, including 2 that I told her I did not think she could win. She just won a case where a tenant put himself in a conflict situation with someone that had been harassing him for a long time. Horrible harassment, racist harassment, a neighbor. But he came home, the guy was yelling at him. He calmly went upstairs, got a baseball bat, came back downstairs to try to talk to the guy and bought the bat for protection. And when the guy started being aggressively physically, he swung the bat. He didn't hit him. If he had hit him, it would have been an entirely other story. He just swung it for protection. I thought that was not going to be okay, frankly. And in fact, I lost a case where someone swung a bat and banged on a banister to get someone to back away from them, who also had put herself into the situation, exited her double lock security door, wooden door and metal door with a bat to confront her neighbors, and then used a bat and swung it at them. And in that case, it was found to be a nuisance. In this case, the jury determined that due to the degree of the harassment, it wasn't a nuisance. Frankly, if that had been a bench trial, we would have lost. So I've got three great lawyers, three lawyers that are, I have many great lawyers, but three that are able to do jury trials. Um, and it's not likely that you would get one of the ones that is not ready to do a jury trial yet by themselves. But we're getting a lot of cases, right? So we have to, sometimes I'm looking at the caseload for the day and, oh shit, are we going to have to send someone out who by themselves? And then usually it ends up working out, but one of these days it's not going to work out, and then we're going to have to reassess the case. And so we need to, who your lawyer is matters as well. And we always go back to, can we win? Sometimes young lawyers from other agencies, or even some of my own, will call and say, they're offering us bloody, bloody, bloody. Should I take it? I don't know. I got to hear the 16 factors, people. So we look at the 16 factors and then we decide whether or not we can take it. Okay. I'm actually going to stop here for, actually, no, because then it messes with the recording. So let's keep going. I'm going to explain the notice. So the notice is the paper that I told you starts the process. The notice will give you X number of days to do X, and they take many shapes and forms. These are the most common: pay or quit, cure or quit, and the minimum number of days required is here, but it could be more than a 3-day. During the period between, I forget when 3088 went into effect, but I think in July and the end of September, it was a 15-day notice. In public housing, it's a 10-day notice. Or a cure or quit, stop violating the lease, or quit because you've done something so bad that it can't be fixed, or a quit for no reason because you don't have rent control, not allowed during the pandemic in LA County until at least January of 2022. No fault notice under rent stabilization. So every rent stabilization law will have reasons that the landlord can evict you. Fault notices is you screwing up, having a loud party, too many loud parties, being a nuisance, breaking the law, etc., or not being able to pay the rent. But there's also no fault reasons, like landlord wants to move in themselves or move in a resident manager or a family member, or take them off the rental housing market by demolishing or converting to condominiums. Those no fault notices under rent stabilization, they were prohibited by the state laws, AB 3088, SB 91, AB 832. Now, no longer prohibited. That went away, but they're still prohibited in LA County because of the county protections, and some of the cities also have that protection. So right now, you still cannot be evicted for a no fault notice. If you have Section 8, takes 90 days. If you're in a rent stabilized unit and the owner wants to take it off the rental housing market, it's a 120-day notice with a possible 1-year extension. And we've added this: if you live in a place and you have a lease, say a 1-year lease, and the lease says at the end of the lease, if we don't take your money, you got to get out, they don't have to give you a notice. Now, most landlords will. They will give you a notice saying they don't intend to renew your lease. Um, in my opinion, this falls under no cause or no fault, but some lawyers are arguing that it's actually a for-cause lease violation. You're violating your lease. We haven't litigated a single one of these yet. No judge that I know of has made a decision on who's right on this point. I say, anytime anybody comes in with a notice, if you can get out, right? If you can get out safely to good and housing that is comparable in price in a comparable neighborhood, go for it. But most people can't do that, right? Most people, even if you've been in a place a very short amount of time, you are below market, and most people are priced out of Los Angeles. So if you've lived anywhere for a year or more, moving out of your apartment probably means moving out of Los Angeles. So the decision to stay has to take into account whether there's someplace for you to go. And if you think that going to live with a friend, or unless it's a good permanent situation, it's probably not a good idea. During the pandemic, a lot of these illegal lockouts are people who moved in with friends and are paying a little bit of money. But my mama used to say, fish and guests start to stink after 7 days. And someone on this webinar said it was more like 3 days. So you really need to know that wherever you're going is a safe place where you can be, and so you can get on your feet and get your own apartment. Briefly, and covered in other webinars in more detail, this is the County of Los Angeles. The County of Los Angeles used to be just one entity, one jurisdiction. But slowly, cities incorporated. There are 88 incorporated cities in the County of Los Angeles. They are in gray. The unincorporated county is in white, and you'll notice these tiny little bits of spaces surrounded by other cities. And red is the city of LA. So, depending on where you live, there may be a local rent stabilization law. We have a local rent stabilization law in all of these areas. And in Baldwin Park, Beverly Hills, Culver City, Inglewood, Los Angeles, Santa Monica, and West Hollywood. We also have an eviction protection law in Glendale. But to get you out, they just raise the rent to market. You can't pay it. They evict you for non-payment of rent. So, but these are the local laws that have protection. If none, and not every unit in each of these cities is protected. Most exempt single family homes. In Santa Monica, if it's a triplex and the owner lives there, exempted. Some exempt duplexes, some don't. All of them exempt units that were built after, and the date will be in the ordinance. So for instance, Los Angeles, no protection for any unit built after October 1978. The dates are different in each of these laws. So we have to know you live in a place that has a law. And it is amazing to me how many Angelinos don't know where they live. People, you live in the county, and so you say you live in Los Angeles, but you really live in a city other than Los Angeles. At the beginning of the pandemic, there was a guy on Facebook just talking about how he told his landlord that I can't be evicted because Mayor Garcetti says I can't be evicted. The guy lives in Pomona. Mayor Garcetti has nothing to do with Pomona. So you have to really know where you live, okay? And then whether or not it's one of these cities, and if it is, whether or not, iPhone, can you please mute? Whether or not your unit is protected. If it is not, then we look at the State Tenant Protection Act. The Tenant Protection Act, which went into effect January of 2020, covers any unit that is at least 15 years old. It does not protect single-family homes or condominiums unless they are corporate owned, and it does not protect duplexes if the owner lives in the other unit. Otherwise, it does protect, and it is not the strongest law. It allows for rent increases of up to 10%. The increase has to be 5% plus consumer price index. Right now, what's allowed is about 6%. And it also has two other major loopholes. One loophole is that if you are you don't become protected until you pay your 13th month rent. So a lot of people who haven't been able to pay during the pandemic, owners are trying to evict them by not renewing the leases. And I just mentioned a few minutes ago, okay, is that a no fault or a lease violation? And we have several cases like that, but none have gone to trial yet. So we're not sure how that's going to shake out. And the other loophole is this substantial renovation loophole, where they allowed to give you a 30 or a 60-day notice. 30 if you've been there less than a year, 60 if you've been there a year or more, saying, we're going to do substantial renovation. We need you to move. So that is allowed, but not during the pandemic in LA County because of the county protections against no fault evictions. So that's a summary. And then of rent stabilization. And then emergency COVID protections. Under these laws, I should add AB 832. Stronger laws in about 40 of the 88 cities. And if the county law is stronger, then it supersedes these. And then the CDC order, it doesn't exist, but it didn't affect most people in LA County. This is what the notices look like. Do you really need to see them? No. The point is, they come in all shapes and sizes. People often complained. It's not signed. It doesn't have to be signed. They can just print the name. It has to be in writing. It doesn't have an official stamp. It didn't come from the court. They don't come from the court. They don't need an official stamp. They just took it off the internet. Well, that's where they take them off of. You can get it off the internet. It has to have required language, and I'm going to show you examples. Please, everybody, mute yourself. If it doesn't have the required language, that's a defense to the eviction. Our practice is to not go running to the landlord to say, hey, you made a mistake. We just let them file the lawsuit and we litigate it and then either win it or get you the deal that you want. Some of our allies in the Stay House Delay Coalition do negotiate with the landlord if there's a defective notice. I think every case is different. And I suppose if you can negotiate something that the tenant really, really wants, that's a great thing. But if you're negotiating a move out based on a defective notice, it's not such a great thing. It's better to litigate the case. They must be handed to you in person. And if you're not there, they can be given to an occupant in the unit and then mailed. And if no one is there, they can be posted on the door and mailed, or they can deliver it to your usual place of business. Tenants often feel harassed by the notices. Oh my God, he sent me so many notices. And really, it was just one. But one copy came to you, one came to your husband, one came to your adult son, and one came to everybody else that might be there that I may not know about, that the owner may not know about. And because you weren't home, they also mailed 4 of them. So you got 8 of them, but really it's the same notice. Don't feel harassed by it. It's the law. It's to make sure everybody gets notice. Another common complaint is they posted it on the door. It was open. It's an invasion of my privacy. We actually fought for it to be open and posted on your door to make sure you see it and know of its importance. They brought it to my place of business. Now, honestly, when landlords do that, they're doing it to embarrass you. So that's not okay. But the law actually, the way the actual law is written, requires them to try at your place of business. Now, there are cases that say that they don't have to. So it's not something that most landlords do. But I do know that when they do, they're doing it because they want to embarrass you. You know what? There's nothing you're going to be able to do about that. The law says that they should try to hand it to you in person. So now I'm going to show you samples of each of these kinds of notices. This is the 3-day notice to pay rent or quit. 2, all the adults get listed here. And all others in possession, people I may not know about. You are in violation of this amount of money owed. This amount must be exactly accurate. I'm sorry, wrong. It cannot be more than what you owe. They can't, even a de minimis, a little amount of overcharge will invalidate the notice. But if they demand less than what you owe, then it doesn't invalidate the notice. And then this one says what the months are. There's no requirement to put what the months are. And if they get the months wrong, that's not a defense, except under the state laws, it has to state what months and be accurate. So during the period of the pandemic, they have to accurately tell you what months you're in arrears. If you don't um, pay or leave, we will file a lawsuit for unlawful detainer. That just means eviction. The accusation is that you are unlawfully detaining, holding on to the unit. And then it should have this forfeiture language. We elect to declare a forfeiture of the lease. If it does not, at the end of the case, if you win, theoretically you can just pay your rent and they have to accept you. And then the date, the name, the person to pay, different person might sign rather than the person to pay. This must be a human being. The address to pay, the phone number, and the usual hours of operation that you can pay. This notice is not valid. It has a defect. Let's see. I think the defect in this one is, I forget the defect, but this one has a defect. This one has a defect. It doesn't have the forfeiture language. We have a lot of cases with this notice, and that doesn't have the forfeiture language. This is the declaration that you should be sending to the landlord if you were not able to pay anything during the pandemic. People ask me, should I keep sending it? I say, sure, why not? It doesn't hurt to send it. It complies with local noticing requirements. So if you're protected by a local law, why not send it? Just add the month. So we haven't fixed this. So if you're not paying October, just add October, add November. What do you do if you get one of these notices? You come to a webinar, okay? We used to do this in person and we will go back to doing it in person, but for now you come to a webinar where we'll explain the law, explain the state law, the emergency protections, other defenses like breach of warranty of habitability. If you have bad conditions, that's a defense to the eviction. If you're protected by a rent stabilization law, you'll be able to figure that out. We'll figure out whether you can pay. If you can pay, pay. Should you pay? If you, by paying, you're going to lose your car and not be able to feed your children, then we've got to figure that out. And we can also make sure that you understand where you're going to get legal help if it turns into an eviction. We also, in those webinars, explain this diagram, which is about what the law that just expired does to protect you from eviction between March and September 30th. We're also going to explain this steps on how you can protect yourself, including what I already said. If you have not applied for rental assistance, as soon as this is over, get on housingiskey.com and do it. We explain the emergency protections and the rent stabilization law, and we do one-on-one consultations. But really, you shouldn't need a one-on-one consultation because we explain it all in the webinar. And if you're paying attention, you will know it. Sometimes I can tell during the webinars that people are doing other things. They're fixing dinner, they're dealing with their kids. You can see them on the screen talking to another person. I'm a great multitasker, but I can tell you that I cannot listen to a presentation like this and do anything else, right? Sometimes I feel resentful that I work so much, so I will put on my TV and work. I'm either working or paying attention to TV. My brain can't absorb both. So if you're in one of these webinars, you should be glued to it and you should be listening because that's how you're going to know the information. And if you still have a question at the end, you stay, we answer the questions. Notice to cure or quit. That's, you've got a lease violation of some sort. They look like this, although it could be different type, it could be different words. 2, all the adults get listed and all others in possession. You are in violation of the lease for premises address. This is what you are violating, the specific paragraph. And you have 3 days to cure by doing this. Here are the witnesses against you. And if you don't quit or cure within 3 days, we are going to file an eviction action and declare a forfeiture of your lease. Ideally, we would at the first sign of trouble assign a lawyer to you, and you'd have, someone to call anytime you needed to ask a question. We don't have enough lawyers. I actually think that on 3-day notices to cure or quit, since they're often about giving up very important rights, like 3-day notice to get rid of your pet that you've had for 10 years and are totally enamored with, or 3-day notice to stop using the side yard that you've always had, I think we should be assigning lawyers, but again, we don't have the resources. So we have you come to the webinars where we explain the state laws and the local emergency protections and other rights, and then you can have a one-on-one and we explain where to get legal help. The notice to quit for nuisance, it could be 3, 10, 30, 60. Looks like this, describing the nuisance. And again, what do you do when you get one? You're coming to a webinar where we are going to counsel you. These notices have such accusatory stuff in it that people want to respond to them. We don't have time to help you respond to them. And if you respond to them, you are likely to screw it up. So apologizing, confessing, don't do that. Make them prove it in court. And so my preference is that you not do it. And I also caution lay advocates like the solidarity caseworkers against it, because I've seen too many where I'm really sorry that I bloody bloody, right? Whatever the accusation is. I won't do it again. But now you've confessed to it, right? So quit, no cause. It's usually a 30 or a 60 day. 30 if you've been there less than a year. 60 if you've been there a year or more. This is a typical one. Again, 2, all the adults get listed here, all others in possession. This is the law that they're basing it on. You're required to leave. And it has to be unequivocally stating they want you out, the address, the date, the landlord's agent. This language is extra. It has to do with what's going to happen with your property if it's deemed, if you don't claim it. And it's a defense to the eviction, and it often is not there. So so that's the same notice, but with a 60-day notice for people that have been there more than a year. This one's defective because it doesn't have the language about reclaiming your property. This one also defective for the same reason. What do you do when you get one? You come to a webinar where we'll explain the law. You'll get a one-on-one consultation and we'll tell you how to get help. No cause evictions. 60-day notice to vacate, 30-day notice to vacate. It can say quit, terminate tenancy. It's all the same thing. Prohibited until 2 days ago in LA County. In LA City, and it's always typo. We just got this one extended in LA County through January 30th, 2022. The city protection, City of LA, have no end. And if you live in another city, you can see what your city is doing by going to Stay Housed LA and finding the protections in other cities in the county button, and then you'll see a tracker where you can look up your city and what's happening in your city. People ask me, will this get extended? A lot of it depends on you. Are you going to get involved? We barely squeaked out an extension last Tuesday. And we would be having greater success at getting earlier extensions instead of this nail biting thing that happens if the movement were stronger. The Section 8 notice, I'm not going to get into a lot of detail, but 90 days are required, and there's a lot of defenses. So we actually retain at these notices, because if you live in a rent stabilized unit, I can get it to go away permanently if I tell the landlord the defects. So in these cases, we will assign you a lawyer and counsel you on the internet. And if you have a digital divide issue, which these cute young kids probably don't, and you put on a mask, we are doing some in person consultations on a case by case basis. And then the Ellis Act, which is you're in a rent control jurisdiction, your unit is protected. The owner says, I'm going to get out of the rental housing market, and uh, serves a 120-day notice. You're entitled to a 1-year extension if you're a senior or disabled. So we actually do open these cases. Again, assign a lawyer, internet, Zoom consultation, or in the office. And we do that because often the landlord is bluffing. If they know you have a lawyer, they'll withdraw. We also want to make sure if you're eligible for the 1-year extension, you take it. And we also want to develop, because it's building wide issues, we want to develop a plan for either saving the units or getting maximum time or money. We want to explore purchase opportunities. And so we are retaining these cases. But mainly it's because it has an organizing potential. So it's not so much about the lawyering as organizing. I think I started off by saying that I'm Elena Popp, Executive Director of the Eviction Defense Network. We are proud members of the Right to Counsel Coalition, established in 2018. I almost said 1918, but 2018. Um, the goal is to make sure that every tenant facing eviction or having problems with their landlords has a lawyer. Uh, during the pandemic, we have formed this stayhousedla.org website where you can learn more about your rights, find other workshops, and get legal help. Um, just to be really clear, this is not a Stay Housed LA workshop. And the reason it isn't is I can't say things like get involved and lobby in the Stay Housed LA workshops. So the Stay Housed LA workshops have to be much more about the law. But I think it's important that people know that they should join the tenants union. They should join the Alliance of Californians for Community Empowerment or Tenants Together, and they should get involved to make laws stronger for tenants. To receive help from the Eviction Defense Network, I'm gonna these slides we put in the I'm gonna put the whole presentation in the chat, but I also want people to have this. And maybe it's not going to let me do it right now. We'll put this information in the chat for people that don't want to download the presentation. So if your case is in the downtown LA, Pasadena, West Covina, or Compton Court, go to edn.la, fill out the eviction prevention form at the bottom right side of the first page, and wait for a response. You might get an error message. Ignore it. Just wait for a response. You submit once. Someone will send you an email letting you know how to connect. If you do not get an email, just come on Monday, Wednesday, or Friday at 6 p.m. to my office hours. I'll look you up. I will either get someone to answer you or I will answer you myself. If you are in another court, you go to stayhousedla.org or use this digital divide number. Note that the digital divide number will take longer for someone to get back to you than just going on the website. Free smartphones are available on safelink.com, government sponsored smartphones. There is no reason for anyone to have a digital divide issue. You need to learn. Okay. I was not very good with any of this technology stuff. I had staff at my disposal to do anything I didn't feel like doing. like learning how to use Zoom. Um, Now I know how to use Zoom. Okay. I have my own Zoom account. People need to really, saying you don't know how to use Zoom is like saying you don't know how to use a telephone. You are going to get left behind if you don't have either a computer or a smartphone where you can access websites on the internet. Please, if you don't have a smartphone, get one at safelink.com. And then we have for immediate lockout situations, 213-340-4714. This is a 24-hour immediate lockout emergency line only. It rings into my cell phone, and I will get angry if you use it to get an update on your case or to avoid coming to office hours because it's not fair. Yesterday I'm trying to have dinner with some friends, and I've got somebody just texting me and texting me and texting me, which makes me want to turn it off. But I can't turn it off because if somebody has an emergency lockout situation, then they won't be able to access help. So please don't abuse either this number or once I send you a text, it texts back to my cell phone. So please don't do that. It's not fair. These are the webinars. They happen every Tuesday. If everybody could please mute. Every Tuesday, every Thursday, every Saturday are the general know your rights. And then the eviction process Saturday at 9 a.m. And then my office hours are Monday, Wednesdays, and Fridays at 6 p.m. These are presentations followed by one-on-ones, although they're not doing one-on-ones on Thursday, and I need to recruit some volunteers to do the one-on-ones on Thursday, frankly. But on Thursday, they just send people to my Friday office hours. So this is the link for office hours. I am now going to show you what these forms look like. This is what a summons looks like. It's kind of scary looking. It looks a little dense, but when you think about it, really you just have to read these instructions. And they say, you're being sued, file an answer with the court, not a phone call, specific piece of paper within 5 working days. And the summons is important because it's what gives the court power over you. So remember that starting yesterday, the landlord cannot get a summons in an eviction unless they declare that they are cooperating with the rental assistance program. This is the courtesy notice from the court. It basically is, they're supposed to serve you the packet with the summons and complaint. They often don't. So the court alerts you about the lawsuit. Don't ignore that alert. You're going to get it in English and Spanish. It's going to come one to you and one to everybody else named in the lawsuit and one to all unnamed occupants. When people ignore this notice and then get a sheriff's notice, we have to explain to the judge why you ignored this notice. So please don't ignore the notice. Go to the court, get a copy. These are other forms that you might see. Anything that looks like a court paper, get it to us because you have to file an answer within 5 working days. This is an example of what an answer looks like. This is a request for entry of default judgment. If you don't file an answer, they have to send you this. So now you've gotten at least 2 courtesy notices from the court and this. And so it's very hard to go to the judge and say, I knew nothing about this until the sheriff posted the notice to vacate. So at the first sign of trouble, get legal help, make sure that you protect your housing. After the answer, there's lots of steps that I've gone through already, but the negotiation piece is the most important. There's all of this. People call, or come on, my lawyer's not doing anything. Your lawyer's doing stuff. They're just not reporting to you everything they're doing. So yeah, you need to kind of follow up with your lawyer and make sure things are being followed through on, but don't make your lawyer crazy because your lawyer has a lot of cases. Motions are, on TV, you see the lawyer is walking down the hall, they see your honor, you can't do that. That doesn't happen in real life. In real life, to talk to the judge, you have to file an application or a motion so the case can get put on the calendar and both sides are there. The motion for summary judgment is a scary motion. You should go on this YouTube video and watch it. It's done whenever there is whenever both sides agree that there are no triable issues of material fact. We agreed to what happened here. We disagree on what the law says about what happened here. Discovery I talked about. These are the trial documents that have to be prepared in order for the case to be sent out to a trial judge. If you lose, there are some post-judgment motions that we can do. The notice to vacate looks like this. It's attached to a writ of execution, which is 3 pages. When you get that to us, we need the little half page with the red and black letters and the other 3 pages. And there are things that you can do to stay in the housing a little bit longer. And there are also motions that address the whatever the reason is you ended up here. Usually I didn't file an answer because I was confused or I didn't get served. And then we have to explain why you also ignored the courtesy notices and the request for entry of defaults. We have to get all those motions done before the sheriff puts up this, which is that final you've been locked out. Again, the Right to Counsel Coalition is a place to get help. These are the courts that handle eviction cases: West Covina, Pasadena, Compton, Long Beach, Norwalk, Mosque, Lancaster, Van Nuys, Chatsworth, Santa Monica, and Inglewood. The Eviction Defense Network is in West Covina, Pasadena, Mosque, and Compton. Other agencies are in other courts, and some courts have several agencies helping. With that, we are going to end. Can you stop recording, Kevin?